If it turns out that you have been sued by your tenant, that's something you're gonna have to deal with, and it's never pleasant. Do you always have to get an attorney? Naturally, I'm going to tell you that I think it's a good idea to talk to an attorney. At the very least, run your set of facts with an attorney. You may ultimately decide to go on your own because you feel confident about the facts, but it's always best to at least talk to somebody about your case. I strongly encourage that every time, no matter what the facts are, just to make sure there isn't something that you've missed. But I want to talk about what the code says. We talked a little bit about a rebuttable presumption, and where that comes in is the tenant will very likely cite the exact provision out of the property code and will very likely say, look, you did X or Y or Z wrong, and because of that, I'm going to charge you treble damages or 3 times the amount, because the code says that any amount wrongfully withheld is subject to this tripling of the wrongfully withheld portion. And so they say, look, I'm entitled to all $1,500 of my dollars. You had no right to withhold any of it from me. And so now I'm going to sue you for $4,500 plus $100. So now it's $4,600 plus my attorney fees and court costs. And so that's when things start getting a bit hairy. Is when they start talking about attorney fees and court costs, because now a $1,500 deposit turns into potentially a $10,000 claim. You want to make sure at the very least that you've spoken to somebody who has experience handling these kinds of cases to make sure you're not neck deep in trouble. Because sometimes the thing that the tenant says is accurate. And if you just are not aware of this accuracy, you might kind of step into a firing range and experience a world of hurt at a trial that you're just not prepared for. So certainly if you've never done this kind of thing before, I don't recommend that you try it by yourself. Get some help, talk to an attorney. Essentially what they're saying is you had no justification for withholding the full amount or a portion of the security deposit. This is why it's always important for you to have actual cost, the actual cost associated with remedying their precise harm. And imagine that you have a Corvette and somebody dings your door and you decide, you know what? I'm going to get this door ding addressed by repainting the entire Corvette. That probably goes beyond what is required to address your actual damage. And so one calculation would be, what was the value of the Corvette pre-ding and what is it now? That's one way to calculate the value of your claim. We talked about carpet earlier. Because the truth is, even after 1 year, that carpet has diminished value. The truth is, it has diminished value the moment it's laid on your floor. It doesn't have the same value that it has, when it's at the store or pre-installation. And so, yes, it's true that things diminish in value over time. That's one concern. It's also true that sometimes a remedy does not necessitate a full extent. If it can be portioned out, if the ding alone could be repaired and that single door could be painted and the car would be just fine, then you can't charge for the full car paint job. The obligation of the tenant is to prove that they were wronged by you and you withheld something without merit. Which is why I always suggest to landlords that you list everything. I don't understand the landlords who come to me and say, well, I could have charged them for this and I could have charged them for that and yada, 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 yada. If you can, you must, because you don't know what a court might deem invalid. But if you've got way more things that you believe are valid deductions that go well beyond the security deposit, you are encouraged to list them. Now, you don't have to say, by the way, I now demand that you pay for all this, especially if you don't have a reasonable expectation that you'll be able to collect it. until you are sued. Make sure that everything that's on your list is, in your eyes, a valid deduction or a valid fee that you can validly charge to your tenant. Don't go making stuff up or inflating costs or giving rough estimates that you're never actually going to use. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. A kitchen is totally destroyed by a tenant. They, for whatever reason, were really bad with drawers and doors, and all of that stuff had to be replaced. And it cost you $2,000 to replace all of that. Or the estimate you got was for $2,000, but you paid Handyman Joe $1,000, and he was able to do it for you on the cheap. Facts like that are going to hurt you. The fact that you claimed it was $2, but it only cost you $1, that's going to hurt you. So you want to stick with actual costs. Make sure that you are able to prove each of the deductions or each of the fees that you assess against your tenant, so that if it turns out that a judge crosses out a few, as long as what's remaining is still sufficient for your claim, you should be fine. You never want to go in with exactly, and I've seen this before, where a landlord will just zero out the deposit and stop counting. That's never a good idea, because you have to presume that some judge is going to see things from their perspective and agree with them and cross out certain line items. And if it turns out that there is some amount that that judge deems was wrongfully withheld, now you can be paying 3 times that amount plus $100 plus all of their attorney fees. So don't put yourself in that position. If there is more that you can assess every single possible cause that you can actually prove, for which you have documentary evidence. Well, you're going to have a harder time proving that as a damage calculation, unless, and here's something that landlords can do, and that I encourage landlords to do. If in your house rules or in your lease or both, you state any repairs that I do, I will charge, and you agree at this rate, $20 an hour, $30 an hour, as long as the rate is reasonable for the kind of work that needs to be done. And that's going to depend on your level of expertise, right? So you may be your own Handyman Joe, and that's fine. If you actually have the skills to do the work, and you would charge any other person X in terms of a flat fee or Y in terms of your rate, you can list that in your house rules or listed in your lease. And now you've got a fact issue that you can point to and say, I ended up doing 4 hours worth of X, Y, and Z work. And because of that, I assessed in accordance with my house rules these deductions to that deposit, as opposed to just willy-nilly making up figures that were not otherwise agreed to by you and the tenant. There's a shift, right? And the court is going to shift to you the obligation to prove that your deductions were each 100% valid. So make sure you have the receipts to prove it, or you have in your lease a preset agreement for your rate or your flat fee for certain services. And then finally, photographs. Photographs and video are going to help you tremendously. If you have photographed the condition of the unit before you ever handed over the keys, and then you have photographs immediately after you get the keys back, that's going to serve as excellent evidence for you. If you are not accurately documenting the condition of your property before the tenant gets access, you're already a step back in the event of some wrongful withholding claim or some repair claim that might come up after they leave. So document. Don't count on them saying, or don't count on them not having filled out the inventory and condition form. You say, whoo, I'm so glad they didn't fill that out. I'm in a great position now. That's just not true. Remember, when the burden shifts to you to justify your repairs, you want to have a baseline. This is what the house looked like before, and this is what it looked like after, and here's what I did to remedy it to get it back to the before condition. If you anticipate this from the beginning, then you document the condition of your property before keys, after keys, and then once you've done the remedy work to relet the premises to somebody else. So that's the way you defend yourself in a wrongful withholding lawsuit